In Crime and Punishment, a shocking update in a case out of Florida. An 18-year-old girl charged with having a relationship with a 14-year-old girl. And she's back in court today. Her name's Caitlin Hunt. She was told to stay away from that younger teenager, but apparently, if the prosecutors are right, she didn't. To the tune of about 20,000 text messages exchanged with that younger teenager since that order just in February. John Zarella takes us back to how this case all began.
Caitlin Hunt appeared to be a frightened 18-year-old, her freedom on the line.
I'm scared of losing my life, the rest of my life, not being able to go to college and be around kids and my sisters and my family.
That was February. She'd been accused of 2 counts of lewd and lascivious battery. The alleged victim, a minor, a 14-year-old female schoolmate. Hunt and her family claim it was consensual.
To hold someone accountable for a felony for having a relationship with a peer, it seems outrageous to me.
Under Florida law, a 14-year-old can't give consent. So if she wanted to stay out of jail pending the outcome of her trial, Hunt was ordered not to have any contact with the 14-year-old. Prosecutors now say she did, and not just once or twice. They say they have 20,000 text messages between the two since the no-contact order. In one, prosecutors say Hunt wrote, quote, "No matter what, if they find out we talked, I'm going to jail until trial starts," end quote. In another, prosecutors say there was this exchange. The 14-year-old texted, quote, "The assistant state attorney asked me today if anyone saw us in the bathroom when we would do stuff. Should I have said names?" Hunt responds, "No, say nobody," end quote. Prosecutors say the texts were sent on an iPod Hunt put in the 14-year-old's school locker after the court ordered no contact. And there were videos sent too, sexually explicit, prosecutors charge. If that's not enough, prosecutors are accusing Caitlin's mother of sending texts to the minor. In one, quote, "Please delete everything and make sure no one finds out you've spoken to Kate at all," end quote. Neither Caitlin nor her mother would comment, and her attorney has not returned CNN's calls.
John Zarella joins me live now from Florida. John, up until this point, it seemed as though there was some sort of a plea deal that was in the works that would not necessarily let Ms. Hunt off, but it would certainly reduce what she could have faced. What's the situation now?
Oh, actually, it would have greatly reduced what she would have faced. She faces 15 years if she's convicted. What the prosecutors had offered her was plead guilty to 1 felony that could be expunged from a record, cleared from a record later on, plead guilty to 2 misdemeanors, and in return, no jail time, no ankle bracelet, community service, and she did not have to worry about being labeled a sexual predator for the rest of her life. At this point, prosecutors say the deal is off the table.
Well, it sounds like it, especially 20,000. I mean, that is a pretty remarkable number just since February. John Zarella live for us. Thank you for that. I want to bring in our legal panel on this because there are a lot of chewy issues when it comes to what's going on in this case and other states as well. Former criminal prosecutor Faith Jenkins is here, as well as CNN legal analyst Mark NeJame. They both join me live. Mark, I want to begin with you since you're from Florida, and this is going on in your state. There are a lot of states that accommodate for peer-to-peer sexual relationships as long as there's a fairly proximate number of years between the teenagers. That a lot of these laws were actually originally constructed to protect young female victims, but we've got 2 females here. But Florida's different, isn't it?
Well, Florida often is different, it seems like. But what we have in Florida is similar to Romeo and Juliet laws that you see in other states, but it's not an actual defense. You can still not give consent at 14 years old. So what Florida allows to happen is that, in fact, if you are convicted and you have a 4-year, 1,460 days, you're not allowed to go a day over that, difference between 2 people under 18 years old, then, in fact, you can go and petition the court to have the sex offender status removed from your record. But you still are punished. It's not a defense.
How many days was that?
1,464 years.
Magically, I'm not good at math, but how many years is that?
4 years.
4 years. So this they would apply.
No, it doesn't seem like it. Faith and I were talking off the set because they were 14 and 18, but now we're understanding that the defendant is 19, and if the victim is still 14, then the state came up with
she's still the same amount of days no matter what. I mean, they age at the same
Yeah, but if in fact they were more than 4 years apart, birthday to birthday.
Here's what I don't understand is in so many of these cases, and you're a former prosecutor, so get me off the ledge here, Faith. There is something called prosecutorial discretion. Some people in this case are saying the only reason that this thing is in the court at all is because there's a bias against homosexuality, that there was a mission on the part of perhaps the victim's parents in this case and the prosecutors to go ahead and prosecute because of the kind of sex it is, not necessarily because of the kind of the case it is. Am I wrong with prosecutorial discretion? Could they have ignored this one?
Well, they could have, but you look at these cases on a case-by-case basis, especially when you have two teenagers in high school. They go to school together, and they're peers, so to speak. And so the prosecutors look at that, they look at the nature of their relationship and decide what they want to do. And in this case, actually, they offered Ms. Hunt a sweetheart of a deal.
It was pretty good.
It was very good. She was not going to be a convicted felon for the rest of her life. She probably would not have been required to register as a sex offender for the rest of her life.
A lot of community service, as I recall.
It was community service, and she would have 2 misdemeanors.
Let me ask you this, and maybe Mark, because it's your state, there is an allegation here that she sent nudes. That Ms. Hunt sent nude photographs of herself, that there were 25 or so of these photographs, and that there was a sexual encounter between the two as recent as a couple weeks ago, and that immediately got my spidey senses tingling that A, sex trafficking of pornography of underage kids, and number 2, additional rape charges for whatever incident occurred recently.
There could be a lot more charges if, in fact, the prosecutors want to go in that direction. I mean, sending videos from an adult to a child is absolutely a federal offense. So that could happen. Faith is exactly right. There should be prosecutorial discretion. The challenge is that every case really does need to be on a case-by-case basis. You can have, under the law, a senior in high school going out with a junior or a sophomore, peers, part of the social group, and be committing a felony.
And it's happened many times before. I wish we could go into a couple of the other cases, maybe on another day, but thank you very much. Faith Jenkins, Mark, NeJame, I'm going to keep you guys very busy, so stick around, don't go anywhere. We're going to talk a little bit more later on in this hour. It's the dog days of summer, and for many kids who are out of school, they're just looking for something to do. It seems to be all of us as parents, our frustration, right? But here's where things get really sinister. A sheriff in Oklahoma says that 3 teenagers were bored, and so they decided to shoot someone dead, an Australian college student, and might have been planning on shooting someone else dead as well. The story next.